Thank you very much, and thank you to Dr. McCaughlin and Dr. Parks, to Aisling and Simone for inviting me here today. I'm going to be talking about, I suppose, an issue that concerns the future rather than the past, but I do want to come back to, if I get time, to talk a little bit about some issues in relation to identity and tracing very briefly at the end. But I am, I suppose, looking at the future, in particular future proposals in relation to joint adoption by same-sex couples. So that my purpose today is to address the topic of adoption as it relates potentially, and I stress that we're talking about future law reform here, as it relates to potential adopters who aren't married to each other, and in particular to same-sex couples and to the children for whom they care or whom they propose to adopt. And I'll be looking in particular at Irish law and the European Convention on Human Rights. In particular, I'm concerned in relation to this issue that we progress in a manner that doesn't replicate the mistakes of the past. In other words, that particularly given what we've heard about issues around tracing, issues around clearly just illegal adoptions, forced adoptions, that we can, I suppose, move forward in a way that doesn't replicate the mistakes of the past, in particular that secures to the child the rights that, to which the child is entitled. So I'm going to start by setting out the context relatively briefly, and then to look at the current legal situation in Ireland, and to consider some interesting cases from the European Court of Human Rights, but I promise I won't bombard you with too much of the detail from those cases, and to look at current proposals for reform, in particular the proposal to extend joint adoption to civil partners, which is contained in the general scheme of the Children and Family Relationships Bill. I mean, things have changed very dramatically in recent years. Marriage is still the most popular option for forming a family in Ireland, but families in Ireland are no longer fitting into a one-size-fits-all template, and there has in particular been a very significant increase in the number of people cohabiting outside of marriage. Census 2011 recorded 143,600 cohabiting couples. That's about 12% of all family units, with an average of 0.7 children per cohabiting couple. There's also been a very significant increase in the number of lone parents with children. Now, some of these are people who've never been married, some are widowed, and some are people who are separated or divorced. But you certainly you have a very significant increase in the number of lone parents raising children, and we also see an increase in the number of gay couples living together and gay lesbian couples raising children. And this emerging family diversity presents a challenge to the traditional template for adoption. As we've heard already, adoption in Ireland was designed originally as a mechanism for addressing the perceived anomaly, as it was seen, of childbirth outside of marriage. And the original purpose was to provide children with what was perceived to be a more suitable, in other words, a marital home environment where this was otherwise not available to them. So this was the template. But indeed, it's still in fact reflected in current legislation, as Aisling pointed out this morning. The Adoption Act 2010 still requires effectively that, unless very exceptional circumstances arise, that the child must be an orphan or be born of parents who are not married to each other. It is still, if you look at Section 23 of the Adoption Act, it is still in general not possible to adopt a child born inside of marriage unless there are very exceptional circumstances, unless the child has been abandoned. Part 7 of the Act of 2010 allows for exceptional cases where children born inside of marriage can be adopted, but the requirements for that are very exacting. So the presumption still underpinning the 2010 legislation is that the marital family is the best family to be raised in, that children born outside of marriage may require transplantation into a more ideal, and I put that in quote marks, family, and that children born inside of marriage will only need this in really exceptional cases. Now, the Children's Referendum and the new Article 42A will allow for adoption of children born inside of marriage once it's implemented, but the new article has been is the subject of ongoing court challenges, and so it more than likely won't come into force at least till the end of this year. There is a growing presence and visibility of same-sex couples, some with children. The 2011 census counted just over 4,000 same-sex couples living together, 230 couples living with children. It's a small number, but this is growing. Since January 2011, there have been 1,467 civil partnerships. So that's just under 3,000 people entering into civil partnerships, and many more who would be deemed to be civil partners by virtue of foreign civil union or same-sex marriage. So you see an increase in the number of same-sex couples and a growing number of couples of the same sex raising children. There are various routes into parenting for same-sex couples, and it's important, I think, to nail the stereotype of in relation to same-sex couples raising children. Same-sex couples are already raising children in many situations as a result of a prior heterosexual relationship, where the child was born as a result of a prior heterosexual relationship to one or other partner in a same-sex relationship. Increasingly, children are being born to lesbian couples as a result of an arrangement involving donor insemination, either a private arrangement or through a clinic. Surrogacy, which is, I realise, a very ethically complex issue, is rare, but it is a growing phenomenon, and it will feature more undoubtedly in the future. Adoption by an individual in a cohabiting same-sex relationship is in theory possible. It's possible for an individual who is in a same-sex relationship to adopt a child, but only as an individual, only on their own. And gay and lesbian couples, particularly lesbian couples, but also a growing number of male couples, are fostering children. While there are very, very few children being adopted domestically in Ireland, and the majority of those children are actually being adopted by their relatives, there is a huge number of children in long-term foster care, and increasingly, small numbers, but increasingly lesbian and gay couples are taking up the mantle of fostering. So there are various ways in which same-sex couples will find themselves parenting children. And this is an area where ideology can often cloud judgment, and I think it's important to put the child very much at the centre of the debate. Look at what is in the best interest of the child given its social reality. And I think it's important not to have a one-size-fits-all approach to this, that different situations may demand different responses. But in this context, I think it's important to note that children are already being raised in these diverse families, and the emphasis should be on ensuring the regularisation of all the relationships with the child to ensure stability and the full recognition of obligations towards the child. I'm not a social scientist, but there is a growing body of research suggesting that the outcomes for children being raised by same-sex couples are as positive as in the case of children being raised by opposite-sex couples. And one example is the US National Longitudinal Lesbian Parenting Study from 2011, which showed that the outcomes for children being raised by, effectively in planned situations by lesbian couples, were as positive as the outcomes for those being raised by opposite-sex couples. The key criteria for family well-being, according to a number of studies, are the quality of family process. That gender and family form don't matter quite so much as family processes, in particular the quality of communication and the quality of family relationships. But again, I think the key point is that many same-sex couples are already raising children, usually in a legally precarious context. And in particular, while the biological parent, if I can put it that way, and it's an awkward phrase, but the biological parent as opposed to the person who is not a biological parent, the biological parent has rights and obligations in respect of the child, but the partner of the parent, either a civil partner or a cohabiting partner, if they're not a parent, a legal parent, they have few rights and no legal obligations towards the child. The partner who is not a parent can't seek guardianship in respect of the child or custody. They're not obliged to maintain the child. They have no obligations. The child cannot pursue their estate on their death. And this was ably illustrated in J. McD versus PL and BM. Family law is full of alphabet soup, lots of cases with the letters. J. McD case involved a lesbian couple and their child, and a dispute with the natural father of the child. The lesbian couple and their child were deemed by the Supreme Court not to be a family for the purpose of the Constitution, and therefore were frozen out of the various benefits that arise to the family under the Constitution. But in particular, the second mother, if I can put it that way, the non-biological parent, was deemed to have no constitutional or legal rights in respect to the child, bar the right of access, very possibly in cases of relationship breakdown, but other than that, effectively the law only recognises the relationship with one of the people who is parenting the child. The situation is not much better in relation to civil partners raising children. Civil partnership is solely reserved to same-sex couples. It replicates most but not all of the rights and obligations that flow from marriage. But one key difference is that civil partners effectively, the civil partnership legislation, generally speaking, ignored the children who were being raised by civil partners. This wasn't for the want of raising the issue with the relevant politicians, but it was felt that this was too sensitive an issue to deal with at that time. So while the adult partners in a civil partnership have most, if not all, of the rights and obligations that flow from marriage, not all of them, but certainly most of them, the relationship between the civil partners and the child, any child that they're raising, is entirely ignored. And joint adoption by civil partners isn't permitted, although lesbian and gay people and civil partners may adopt as individuals in principle, although there are certain caveats there, but a sole adopter may adopt if it is considered to be desirable and in the best interest of the child. But joint adoption by civil partners is not permitted. You've got to be married in order to adopt jointly as a couple. There are proposals in the Children and Family Relationships Bill 2014 to change this situation, and in particular to allow civil partners and cohabitants to become guardians of their parents' children if that is in the best interest of the child. A guardian is somebody who has responsibility for the child and has various obligations to defend the well-being of the child during the time that they are a child, and there are proposals, subject to certain conditions, to extend guardianship to civil partners and cohabitants of parents. There are proposals to impose maintenance obligations, in other words, the obligation to financially support the children of your cohabitant or civil partner, even where they are not also the parents of the child. There are requirements in the proposals to ensure that the interests of children be taken into account, for instance on the dissolution of a civil partnership. It's remarkable that a civil partnership can be dissolved without having to take into account the interests of the child as a precondition to dissolution. And most importantly for this purpose, there is a proposal that civil partners specifically, but not cohabitants, will be allowed to adopt as couples, to adopt jointly. Moving on then, I suppose, the current law in relation to eligibility to adopt. I wanted to stress first that, it's interesting to contrast what's down on paper and legislation and what actually happens in practice can be very different, as we heard this morning. But the welfare of the child is supposed to be the first and the paramount consideration. There is no constitutional or convention right to adopt. Nobody has a right to adopt per se. Adoption has to be viewed from the perspective of what is in the best interest of the child. And it's important to stress also that eligibility is not the same as suitability. The fact that somebody is eligible to apply, as Lord Hoffman pointed out in the House of Lords and Rapee in the UK, eligibility to apply is only the first step on the road to adoption. Being eligible doesn't necessarily mean that you are a suitable parent. That is a separate issue. But as the law stands at the moment, while there's no bar on lesbian or gay individuals adopting as sole adopters, provided that they are otherwise suitable, a couple wishing to adopt in Ireland must be married to each other and living together in order to effect a joint adoption as a couple. And the same principle applies to Irish couples who want to be declared eligible to adopt abroad, to effect an inter-country adoption. They must also be married to each other and living together. So it would appear certainly, and some people argue about this, but a civil partner on his or her own may potentially adopt as a sole adopter. His or her living situation will be considered in that context. There doesn't need to be anything to prevent that. But civil partners may not adopt jointly, either domestically or by means of an inter-country adoption. Now I know tomorrow you'll be dealing with inter-country and foreign adoptions. In practice, I should point out that it can be very difficult, even for lesbian or gay individuals, to effect an inter-country adoption, as many what we would call sending countries refuse to allow lesbian or gay people or same-sex couples to adopt. And even where same-sex couples do manage to adopt in a foreign country as a couple, there's an interesting question mark as to whether that can be recognised in Ireland There's a public policy exception in Section 57 of the 2010 Act, and that placed a question mark over whether or not such foreign adoptions or foreign inter-country adoptions which recognise same-sex couples as joint adopters can be recognised in Ireland. And I don't have a ready answer to that, but I think that that's something that may ultimately have to be determined by the courts. I wanted to, I suppose, briefly refer to the European Convention on Human Rights, because there are a number of interesting cases under the Convention in relation to adoption, and particularly adoption by same-sex couples. Again, it's important to note that there is no convention right, no right under the European Convention on Human Rights to adopt or to found a family. The Convention protects family life, but it doesn't guarantee you a right to have a child, or indeed to adopt a child. Adoption is not intended as a mechanism to address, what is a very legitimate aspiration to be a parent. However, the European Court of Human Rights has consistently stated that Article 8 of the Convention, which protects private and family life in particular, doesn't guarantee a right to adoption per se. It doesn't safeguard the desire to found a family. However, what it does say is that once a state permits adoption, it must apply its rules fairly, and in particular it cannot discriminate without a very, very cogent reason. It can't discriminate between opposite-sex couples and same-sex couples outside of marriage. Article 14 of the Convention requires that there be no discrimination in the application of other Convention rights, particularly the right to family and private life. And sexual orientation and marital status have both been recognised as grounds upon which discrimination is precluded. And so, for instance, in the Silva Muta against Portugal, a gay father was denied custody of his child, and this was a child he'd had from a previous relationship. And he was effectively denied custody on the basis of his sexual orientation. This was the key reason why he was excluded. The Portuguese appeal court had ruled that the child should live in a traditional Portuguese family. They said it is not our task here to determine whether homosexuality is or is not an illness, or whether it is a sexual orientation towards persons of the same sex. In both cases, they said it is an abnormality, and children should not grow up in the shadow of abnormal situations. So they kind of shot themselves in the foot, because the ECHR found that this is a clear breach of Article 8, read in conjunction with Article 14. Effectively, the Court of Appeal made a distinction based on sexual orientation, and they said that this is not permitted. The Court cannot find that a reasonable relationship or proportionality existed between the means employed and the aim pursued. So effectively they were found to be in breach of the Convention. In Frede against France, the European Court of Human Rights found that states could decline to allow adoption on the basis of sexual orientation of the applicants. But in 2008, the ECHR changed its mind effectively. It said that where individuals are allowed to adopt by a state as sole adopters, a state cannot discriminate against the prospective adopter on the basis of sexual orientation. In EB against France, a woman who was actually a specialist in nursery school education was denied eligibility for adoption or suitability for adoption. The court found effectively that she'd been denied primarily on the basis of her sexual orientation, and the court found that there was a breach of Article 14 in conjunction with Article 8. It is possible, it would appear, to reserve what's called second parent adoption to married couples. Now, second parent adoption is where one person is married to another person or is in a relationship with another person. The first person has a child and they want their new partner or spouse to become the legal parent of that child. Now, many countries allow second parent adoption subject to conditions. Ireland does not. In Ireland, if you are the spouse of a parent and you want to adopt a child, the parent has to give up their child for adoption, and both parties have to jointly adopt the child together, which is ludicrous. And of course, it's only possible where the couple are married to each other. It's not possible in the case of civil partners or cohabitants. But there are other countries, France, England and Wales, Austria, that allow second parent adoption. But in some cases, for instance, formerly in France, second parent adoption is restricted to married couples. And in Gaston-Dubois against France, the European Court of Human Rights found that it is possible to reserve second parent adoption to married couples, provided that opposite sex and same-sex couples outside of marriage are treated equally. But in a recent case called X against Austria, the court pointed out that where a state permits adoption by an opposite-sex couple outside of marriage, it can't exclude same-sex couples. Allowing unmarried opposite-sex couples, but not same-sex couples, to access second-parent adoption, they found again breached Article 14, the anti-discrimination provision, read alongside Article 8. The court found that the government in Austria had failed to adduce particularly weighty and convincing reasons to show that excluding second-parent adoption by a same-sex couple when unmarried different-sex couples are permitted to access second-parent adoption, they failed to prove that this is necessary to protect the traditional family, and the distinction was therefore found to be in breach of the Convention. It is worth noting the provision of the European Convention on Adoption. Now, there are two versions of this. There's an old version, which I believe we're still a party to, which confines joint adoption to married couples, but a 2008 revision would allow states to extend joint adoption to registered partners and same-sex couples, as well as couples in a stable relationship, but it's an option rather than a requirement. As I understand it, to the best of my knowledge, Ireland is still party to the old version and not yet party to the new version, 2008 revision. Now, in relation to proposals for reform in Ireland, and apologies, I'm clipping through this rather quickly, the general scheme of the Children and Family Relations Bill 2014 has proposed effectively a number of reforms, but most notably to extend joint adoption to civil partners. And again, civil partners are same-sex couples in a registered union. The general scheme of the Children and Family Relations Bill is a gargantuan piece of legislation. It's only a proposal at this stage. There's no guarantee that it will become law. There's no guarantee that it will become law in this current form. But generally, the bill as proposed introduces a much greater flexibility for the recognition of diverse parenting relationships. And there's a move towards a greater facilitation of what we might describe as social parenting. People who are not biological parents, but who are nonetheless fulfilling a parenting role. Now, the scheme in particular proposes to allow civil partners to adopt jointly. This will require that both spouses and civil partners will be treated the same in respect of eligibility to adopt. Now, they've chosen not to extend this right to cohabitants, and I'll speak about that in a moment, but they're confining it to spouses and civil partners. It's worth noting that civil partners and same-sex couples are already allowed to foster, and in many cases are fostering children long-term, and that LGBT people and civil partners as individuals are already eligible to adopt, subject to certain conditions. So it does seem logical to allow joint adoption where this is in the best interest of the child, but I think it's vital to remember, again, as I pointed out before, that eligibility is not equal to suitability. Being eligible doesn't mean that the couple, the particular couple, are suitable as adopters. That has to be determined on a case-by-case basis. Eligibility is simply the first part of the process. The best interest of the child genuinely has to be the primary consideration, and adoption in this context must be considered primarily by reference to whether it actually improves the position of the child, not simply as a means to provide children for intending parents. And again, I stressed it already, many of the children I'm thinking of and talking about are already living with and being raised by same-sex couples, and joint adoption may be a means, not in every case, but in some cases, to regularise the position of the child, particularly vis-à-vis the parent who has no legal obligations towards the child. There are two interesting cases from the UK in this context. P and others from 2008 is a decision of the UK, what's now the UK Supreme Court, which found that Northern Irish law, in preventing unmarried couples from adopting jointly, infringed the European Convention on Human Rights. The relevant legislation in Northern Ireland effectively had prevented unmarried couples who were living together, who wanted to adopt jointly, from doing so. Now, while the House of Lords pointed out that it wasn't unreasonable to say that marriage and civil partnership, in particular marriage in this case, is a more stable environment in general in which to raise children, but having a blanket ban on all unmarried couples adopting, regardless of the circumstances, they said, was effectively disproportionate. So they found effectively that an unmarried couple should be allowed to adopt jointly. They effectively found that the adoption order the relevant legislation was contrary to the Human Rights Act and the Convention on Human Rights. The Northern Ireland Human Rights Commission application is effectively an application of the P decision in Northern Ireland. In the Northern Ireland High Court in 2012, Mr Justice Tracy found that a ban in Northern Ireland on unmarried couples adopting together and a ban on civil partners in Northern Ireland adopting either together or separately infringed the Convention. In Northern Ireland, not only were unmarried couples prevented from adopting, but civil partners either together or separately were deemed ineligible to adopt. And Mr Justice Tracy again found that the relevant legislation was contrary to the Convention. I think in this context, I suppose the reason I'm raising these is that it will be welcome, I think in my view at least, to see the right to adopt jointly extended to civil partners, but we do also have to think seriously about the condition and the situation of cohabitants. Is it appropriate to have a blanket ban on cohabitants, regardless of their circumstances, adopting jointly? Now, you may well say to cohabitants, well look, if you're a same-sex couple, you can have a civil partnership, you've got a choice, or if you are an opposite-sex couple, you can get married. But there may be circumstances, there may be reasons why people may not be able to or want to get married or have a civil partnership. There are some same-sex couples that in principle object to the concept of civil partnership, and one has to respect that view. So having a blanket ban and maintaining a blanket ban on cohabitants, regardless of their circumstances, jointly adopting may ultimately be found to be contrary to the Convention. Is joint adoption the solution? Well, it's arguable that, and again, it's important to look at the individual circumstances. For children being raised by same-sex couples already, this potentially provides a more stable foundation for family life. The child acquires rights in respect to both parents, and crucially, both can make important decisions in respect to the child. The adopters assume full parental rights and obligations in respect to the child. On the other hand, it is important to note that adoption terminates any pre-existing rights and obligations of biological parents. It's a very final and a very dramatic mechanism. And as I've argued before, I think here in Cork, in some cases extending guardianship may be a more appropriate solution. Though guardianship has its drawbacks, in particular guardianship only lasts as long as you're a child. The status of guardianship, unlike legal parenthood, ends when a child reaches the age of 18. Adoption also can be blocked quite appropriately by the mother, by guardians, by persons with charge of or control over the child, so it's subject to the consent of a variety of people. The parties must meet suitability requirements, and of course the child loses their rights in respect to other biological parents. There are issues of identity also that have to be grappled in this, and I think it's important that moving forward that the issues in relation to identity are dealt with. It's important to note that pending the implementation of the Children's Rights Amendment, a child born inside of marriage can't be adopted, and it may be some years before that is resolved. So there are pluses and minuses certainly to joint adoption as a solution. In summary, I think joint adoption for civil partners would be a welcome step, and it would help to regularise the position of many children being raised by same-sex couples, but it isn't, I think, the only solution, it's only part of, I suppose, a solution to this particular situation. These are complex and intricate situations. I think Susan has said that, well, complexity isn't a reason not to legislate or deal with this. There are a complex matrix of relationships that have to be considered, and there is no one-size-fits-all solution in all of this. So joint adoption is part of the solution, but only one part. But it certainly offers potential in some cases for offering greater stability and security for the child in the environment in which he or she is being lawfully raised. I just wanted very briefly to make some comments on identity and access to information, because I think that's been a highlight of this particular conference so far. I think it's vital that adopted children, at least in adulthood, and possibly earlier, are allowed to access information relating to their origins. And it's already been pointed out that this is a constitutional right. It's a constitutional right, and indeed a right under the European Convention on Human Rights, to know your identity and access identity through access information to identity, in particular as confirmed by the European Court of Human Rights in Mikulic against Croatia. This, of course, has to be balanced against the privacy rights of birth parents, where those privacy rights are asserted. But I think it's important not to overemphasise the significance of privacy. Privacy should not be used in particular as a smokescreen to protect the interests of states or the reputation of adoption agencies and or the various denominations or churches. I suspect very often privacy is being invoked very much as in the interests of the various denominations in particular and the agencies rather than out of genuine concern for the mothers involved. In IoT against B, it is true to say that while confirming the right to identity, they also pointed out that the right to identity had to be balanced against the constitutional right to privacy. But the word balance is the important right there. They did not say, and in fact they made it very clear, that privacy rights are not absolute. They did not say that privacy trumped the right to identity. The Supreme Court in IoT against B said that it's up to the legislature, up to the national parliament, to balance privacy rights against identity rights and decide what is the correct balance in those circumstances. They made it clear that privacy rights are not absolute, although it has to be said that the privacy interest has been given some weight by the courts, particularly in the South Western Health Board against the Information Commissioner decision and in the Northern Area Health Board decision as well. The courts in practice do tend to lean very heavily in favour of privacy, but privacy rights are not absolute. In IoT against B, the Supreme Court laid down a number of points or issues that needed to be considered in deciding whether or not to balance and how to balance those interests. The privacy rights, I think, do have to be respected. As we've heard this morning, there are many women who are terrified of their families finding out about their circumstances, but equally, I think it's not fair to assume that every woman who has placed their child for adoption wants it to be kept a secret. Privacy is as much about intimacy and the right to an intimate life as it is about secrecy. The European Court of Human Rights has emphasised again the right to know one's identity, particularly in Mikulic, although again they pointed out that it has to be balanced where appropriate against privacy interests. It is worth noting that under the legislation, the courts and the adoption authority can release information from the adoption index if it's in the best interest of the child, but they seem very reluctant to do so, and it seems that privacy rights are very much the key concern in their mind. But again, it's important to note that privacy is not an absolute right, and it has to be balanced against the important right to know one's identity and origins. It's worth noting, I think it's been pointed out already, that in England and Wales since 1975, adopted children have been able to access their birth certificates on reaching adulthood, and I know there are a number of UK commentators who I hope will be able to address that and address their experience there. And there are a number of Canadian jurisdictions that also allow a right to access birth records on adulthood, subject to, and I think that maybe it's the wrong word, but an information veto, and I know that there are issues around information veto, but effectively the presumption is in favour of releasing the information, subject to, I think what Anne Fergus was talking about this morning, the natural mother actively taking steps to protect her privacy, but that we would not assume, in the absence of being told, that the natural mother wishes to assert her privacy. So those are just a few thoughts. I mean, the key point being that in that context, that the right to identity is a constitutional and a convention right. Yes, it has to be balanced against privacy, but privacy is not, nor should it be, a trump card. It is certainly something to be respected, but I don't think it can entirely close off any further inquiries, and in particular in relation to non-identifying information such as medical records. I think the balance in that case might be tipped in favour of supplying that information, at least non-identifying information. So that's all I wanted to say. Thank you for your attention, and I think we might be able to address questions maybe later. Thank you.